день, господин Белот. Сразу хочу сказать о том, что у нас в эти дни в связи с событиями, связанными с пандемией, развернулась очень большая такая работа по международной студенческой, аспирантской, преподавательской научной весне. Обычно каждый год наш университет в эти проводит большую конференцию, где мы встречаемся вместе, обсуждаем важные проблемы. Сегодня в условиях пандемии так получилось, мы работаем контактно, мы работаем дистанционно, и мы очень рады такой возможности сегодня порассуждать по актуальным проблемам, связанным с развитием международного права, международного арбитража, послушать вас. Сейчас 60 участников, которые как только узнали, что вы будете проводить встречу, сразу захотели с вами поучаствовать, послушать вас, задавать вопросы. И в основном у нас это наши ученые, аспиранты, студенты, юристы, те, которые так или иначе сталкиваются с разными вопросами в праве. Я благодарю вас лично за то, что вы нам предоставили возможность опубликовать научную статью по актуальным проблемам международного права в нашем журнале. Он скоро выйдет. И я думаю, что мы продолжим сотрудничество и после выхода этой статьи. Мы с большим удовольствием готовы вас слушать, задавать вам вопросы. Спасибо.
Спасибо огромное. Спасибо большое. Ну, как вы говорили, я в Париже. К сожалению, Эйфельной башни не видно. Но я здесь. И я буду вам дать сегодня мой тема. Достаточно хорошо говорю по-русски. So, is setting aside of an arbitral award abroad is not an obstacle to its recognition and enforcement in France. To start with, we can say that each sovereign state has a monopoly on coercive processes in its territory. At the time of enforcement of the arbitral award, it will often be necessary to obtain the consent of the local state judge in order to obtain the force. In this moment, the local legal order will put its condition to give effect to the award on its territory. For example, the enforcement of an arbitral award is subject in all countries to a prior procedure of exequatur for the enforcement of that award. Each state decides for itself to grant or not binding effects to the arbitral award on its territory. The effectiveness of the international arbitral award depends in part on the fate that will be reserved by the court or the seat of the arbitral tribunal. The action for setting aside shall generally be brought before the court of the seat of the arbitral tribunal, and the law of the seat of the arbitration shall be used. A strong relocation of the international arbitral award to the seat of could have taken place if special confidence were given by the other states of the judge of the seat regarding the international validity of the award. The influence of the seat judge would thus have been considerable if an international arbitral award set aside in its country This confidence in the judge of the seat by the foreign states is, however, limited. It is limited, first of all, the states never place any particular confidence in the decision of the judge of the seat who rejects the action for setting aside. For example, the Paris Court of Appeal has decided that the French judge should review the award even if the action for setting aside before the seat judge was dismissed. Our perception that this solution is almost unanimously adopted in comparative law. The states refuse to recognize the least effect on their territory to this decision of setting aside, which implies a favorable opinion of the validity of the award from the judge of the seat. Secondly, the states grant the confidence that depends on whether the award was or not set aside by the judge of the seat. France, for example, gives no effect to the opinion of the judge of the seat when this one set aside an award. Indeed, under French international arbitration law, the setting aside of an award abroad is not a ground of its ineffectiveness in France. Thus, for example, in the case North, an award granted to Vienna side by the Court of Appeal of Vienna was able to obtain the execution is based on two cornerstones. Firstly, Article 1520 of the Code Civil of Procedure, which exhaustively, comprehensively lists the objection that may be raised against the recognition and enforcement of an award in France, does not mention its setting aside in its country of origin. Secondly, Article 7 of the New York Convention of 10 June 1958 provides that the provision of the Convention shall not deprive the interested party of the right it may have to rely on an arbitral award in the manner of the country where the award is called upon. In other words, Article 7 of the Convention allows the judge of the country where the enforcement of the award is sought to apply its own law if it is more favorable to the recognition and the enforcement of the award than the Convention. However, by not retaining the setting aside of the award in its country of origin as a ground of refusal of enforcement, French law is more favorable to this solution based on the philosophical idea that an international arbitral award is not part of any legal order in which it was rendered. The arbitral tribunal being an autonomous international jurisdiction, so-called international justice. Thus, in the case Il Marton, which is a very famous case in France, rendered by our Cour de Cassation on March 23, 1994, an award set aside by the Swiss Federal Court obtains the exequatur in France, since for the Cour de Cassation, the award, I quote, the award rendered in Swiss law was an international award that was not integrated into the legal order of that state, so that its existence remained despite its setting aside. In another case, very famous as well, called Putrabali, the first civil court of the first civil chamber of the Court of Cassation noted that, and I quote again, an international award that is not attached to any state legal order is a decision of international justice of the rules applicable in the country where its recognition and enforcement is sought. Pursuant to Article 7 of the New York Convention of 10 January 1958, the company Rena Holding was receivable to present in France the award rendered in London on 10 April 2001 in accordance with the arbitration agreement and the IGPA rules, and founded to avail itself of the provision of the French law of international arbitration, which does not provide the setting aside of the award in its country of origin as a ground of refusal of recognition and enforcement of the award rendered abroad. Since the recognition in France of this award was no contrary to international public order, according to French perception, the exequatur had to be granted. Moreover, another effect of this French position, the authority of res judicata, of the decision of exequatur for setting aside award, was opposed to the recognition of any effect in France of the second award rendered by the new arbitral tribunal established after the first award had been set aside. Finally, since the setting aside of an award by the courts of the state in which it was rendered is not being likely of giving rise to refusal of enforcement, there is also no need for the French judge of exequatur to stay proceedings pending the decision of the foreign court in charge of the action for setting aside. This position of French international arbitration has, of course, some advantages and also disadvantages. Let's start with disadvantages. First of all, it has an obvious drawback of condemning any international harmony of solution. It is then a source of unpredictability for the parties, since it can lead to an indefinite uncertainty as to whether an award which has been set aside at the seat is in fact null and void, or whether it can, in despite of everything, be enforced in one or another country. The parties who rarely waive the action for setting aside in advance want this review of the setting aside to have an effect beyond a simple declaration of annulment, particularly as regarding the future of the award and their situation. Moreover, the French solution will often lead, in view of a frequent implementation of a second arbitration, following the setting aside of the first award, to an international competition in the matter of enforcement between two awards for the same arbitration. The advantage of the French solution are, because there is one, granting special authority to the decision to set aside the award rendered by the seat would favor an excessive imprint of the seat's law on international arbitration, and that the reception of the award on French territory must be assessed solely on the basis of requirements and criteria laid down by French law without worrying about the reception reserved for this award by another judge, whether the seat or in another state where enforcement would have previously been requested. It can be pointed out that an intermediate solution was adopted by some states. You can, for example, say United States and all. Namely, that the judge of the place of enforcement acknowledges that the decision of setting aside an award rendered by the foreign judge of the sea may, if necessary, object to the enforcement of this award in its territory, provided that the judgment of setting aside satisfies the condition for recognition of foreign decision in force in the requested states. To conclude, we can conclude by taking the example of the Yukos case. We can say that this position of French law explains the fact that the setting of the final arbitral award in the court of first instance of The Hague in the Yukos case had no effect on the rights of the three companies of the former shareholders of Yukos or on the adoption of measures enforceable on the basis of the three final decisions rendered by the arbitral tribunal on July 18, 2014, condemning the Russian Federation to pay a principal amount of I will speak broadly, $50 billion in favor of ULA, Yukos Universal, and Veteran Petroleum. Whatever the outcome of the setting aside action vote in Holland against the award rendered by, in this case, this arbitral award, which reserved exequatur in France, will be and is unacceptable. Thank you very much.
Спасибо огромное, господин Белота. Уважаемые коллеги, как мы договаривались с вами, у нас уникальная возможность встречи и уникальная возможность задать вопросы. Я знаю, что в чате появились вопросы, и я, наверное, приглашу юридический факультет, поднимаем ручку, кто хотел бы задать вопрос. Так, Владислав, отлично. Да, слушаем вас.
Dear Frederick, can you explain me? You said in your lecture that the French system, French judicial system, is very fair, is very objective, and how can you comment, for example, the freezing of the financial resources of this Russian embassy in 2007 in France?
Yeah. Mm-hmm.
And simultaneously in this period were arrested the financial resources of our central bank in your country. Can you explain me what's your opinion about actions, please?
Okay. I think you mentioned the enforcement NOGA or the rendered in the NOGA
yes,
case.
Exactly.
Yeah.
Exactly.
Yeah. It's 2007. I didn't work on that case, but I work on the Yukos case because my client, who is a Russian company, got the highest, the biggest, the largest seizures of his assets in France. And my client is a private company. So I know quite well about that case, I mean, from the French point of view, about what happened in France. So what you must know about the French system of international arbitration is that French legislation, French doctrine considers that arbitration, international arbitration, particularly speaking, is not belonging to any local, say. It is private justice, and when it is in relation with international businesses, international commerce, it is international justice, according to the definition of our French Code Civil. So if the judge in charge of the exequatur, or just in charge of recognition of the decision in France, of the award, I mean, considers that it is international award, international arbitration, he will just pay attention about the award itself, and he will absolutely not consider what happened. I'm talking about quashing, the setting aside of the decision in the country of the arbitration. Maybe the parties or one party will ask for quashing, the setting aside of the decision, but the French judge in charge of exequatur will absolutely not care about that, because he considers that again it is an arbitrational award, international decision, international justice. So the decision of a local judge in The Hague, for instance, absolutely does not matter.
Okay, thank you. You know, show in Paris, I suppose. Le Bourget, yeah. No, the case about the escaping of 2 Russian military planes from France, from Le Bourget. when, in accordance with the international arbitration, I don't know how are they called, the people who belong to the enforcement officials, they went to the airport to the pilots knew about it, and they and went out to Moscow. Did you hear about this case?
I think it's still about the Noga case, because they tried to size. I think it was two plane. It was what's the name of the? I mean, it's two Russian military plane. It's a very famous plane. Sorry, I forgot the name. They tried to size as well a boat, school boat from St. Petersburg, and they tried to as well to say some paintings of Pushkin Museum. So finally, I mean, it was. I mean, this should be linked to the personality of Mr. Garon. Mr. Garon, who was the manager or the owner of Noga Corporation. He was quite a special person. So yeah, because when you have to try to get enforced an award, you try everything to put pressure on the other party, and I think that was part of the tactics of Mr. Gaon to put pressure on Russia and to find a settlement with Russia, and I think that's what he managed to do.
Okay, thank you. In any case, I would like, if there will be possible, to communicate live after all those things with the coronavirus. You see, maybe you will come to our entity, to our university, and we shall continue our discussions. I mean that our discussion.
Yeah.
I hope that our discussion will be very fruitful.
Yeah.
Okay. Thank you. Goodbye.
Thank you.
Hope you will be okay.
Thank you very much.
Bye.
Спасибо большое.
Thank you.
Спасибо огромное. Константин, Наталья.
Bonsoir. Merci beaucoup for performance aujourd'hui. Thank you very much. And my question is following. Could you introduce some interesting keys from your legal track related to international law, please?
Repeat. I don't hear you very well. More loudly.
Could you please introduce some interesting keys from your legal practice related to international law?
Oh, that's quite large issue. You have many cases, of course, because as you know, the International Chamber of Commerce is based in Paris, and Paris is one of the places where most of the commercial international arbitration took place. You know, you have Paris, you have Geneva, London, commercial arbitration. So you have many cases. So I can tell you about, if you want, about why I choose Paris as a seat of arbitration. It's one of the reasons I choose to talk to you today about how France consider arbitration as international justice. If you choose some other countries, you can have a disconfidence about arbitration and international arbitration. In Paris, you have a legal system who is very, very favorable to arbitration, to international arbitration, particularly speaking. If, of course, the arbitration respects international legal order for French perspective, of course, and that the parties have given putting in place an international arbitration. Of course, you will get very, very good, let's say, respect of your will, and you will have a fair international arbitration based on the French civil code, which is very, very modern. That's not the case in other countries which does not have those tradition. For instance, in England or in, let's say, don't consider international arbitration as, let's say, something equal to justice, state justice. And this tradition, I mean, they quite are quite opposed, in fact, to international arbitration, and they consider that that's really a secondary way of rendering justice. And this tradition of common law, you can see it in Africa, for instance. In English-speaking Africa, you have disconfidence in international arbitration, and you have very interesting cases. For instance, in Sudan, for instance, can be in Kenya, but Sudan is very, very well known for, let's say, attacking arbitrators by the English way of contempt of court, So if a local judge or judge of Sudan considers that the arbitration is contrary to his local public order, or is contrary to his local jurisdiction, he can ask the arbitral tribunal, to stop immediately arbitration. And if the arbitrators do not obey, they can be sent to jail. Decision rendered by the local judge of contempt of court. So it's more secure for parties to go to have a seat of arbitration in France or in Geneva, because they will be able to rely on a modern legal system. That does not mean that the venue of the arbitration should be in France or in Geneva, but this can meet, the arbitral tribunal can decide to meet anywhere else. But it's very, very dangerous when you work with African-speaking countries and you are tempted to go in London, or you are tempted, you can go to London, or you can go in France, or you can go in Paris or in Geneva. It will be much more secure for the arbitration and for the parties and for the arbitrators, because in those countries, and I've here example in mind, you can really be sent to jail, and that is even dangerous for an arbitrator to arbitrate and to participate in an arbitration when you are opposed to the states. My answer.
Спасибо огромное. И у нас Константин.
Good afternoon. How do you think international law compares with national law?
Once again?
How do you think national law compares with national law?
Sorry, I will repeat your question. How do I consider international law compared to national law, right? Is that correct?
Yeah.
Yes, yes.
Okay. Well, that's a very, very important question. I'm not sure I will have time to talk about international law against versus national law. I can say that national law is made by the people, and that national law exists because it is voted by the representative of the people, by elected people, elected persons. So it has legitimacy. International law is first of all an issue of a matter of procedure to determine which national law is applicable. But we will not talk about that with a rule of conflict and so on. Is international law exists? Answer is quite complicated. Of course, I can talk to you about Lex Mercatoria. So according to Lex Mercatoria, yes, it exists. According to international conventions, yes, it exists. Convention voted and ratified by countries and by their representatives. So international law exists. And maybe your question is, does international law must supersede national law? Because I know that's an issue raised now in Russia regarding the reform of your constitution. My opinion is that no, international law should not supersede local law and national law, except if you accept by conventionally, that by ratifying a treaty, that your convention, that international law, I mean a convention, because it's not international law broadly speaking, it's a convention that is ratified by your representative, by your parliament, is made to supersede local law. I'm talking, for example, about human rights. So in that case, yes, it is possible. But just because you have decided the convention, to supersede your local. Well, I hope I answered to you properly.
Thank you. Yes, thank you.
Thank you, Pavel.
Я так понимаю, Глотов Сергей Александрович еще. Сергей Александрович хочет выступить. Сергей Александрович, я вам права ведущего предоставил. Ага. Да, Сергей Александрович.
Андрей, слышно меня, нет?
Да, отлично слышно.
Да. For this election, my question for Mr. One question. What do you think about situation, what your opinion about situation coronavirus and new convention about coronavirus? And second question, right in European country and coronavirus, what do you think about this problem?
What do you think of this in European countries, right?
Yes. Coronavirus and human rights situation in European countries, in French, German, Russian Federation, Italy.
Okay, all right. this virus made very strong shock, to our local, to our legal systems, because we had to change very quickly our legislation, first to control the movements of the people on the territory, and people are blocked at home, so they are confined in their home. They can't go as they want freely, and that's let's say a big constraint and a big limitation of our rights, and rights which are protected and granted by the Constitution. So constitutional rights, and so it is limited in the time, of course. It can't be permanent. It is just because it is accepted by our parliament, and because it has been voted, because it's not the only the government which can decide that on its own. It must be accepted by the parliament. There is still a control of by the parliament on the executive order. That's the first thing. The second thing is that it's very linked to economic situation, and coronavirus is again a big challenge for our economies, and we have to adapt our way of consumptions. And for instance, there will be limitations for travelings. There will be kind of limitations. So honestly, what will going on, what will happen, we don't know. We just know that it's not permanent. It's something which is limited in time, and we are very surprised, very much surprised, because that never happened. Anyway, we are not going to abandon our rights like can be done in some countries. For instance, we don't want to be too much controlled by some applications on smartphones. We don't want to be too much looked by the states, by some people who maybe are not elected. Because the parliament can constrain the people and can empower some some representative of the states to control the people. So nothing yet has been voted in our parliament regarding this control, and of course we have civil rights, so those rights will not be abandoned because we are at risk, so there must be a balance between abandoning rights and protecting the population, and it is a very difficult and delicate balance, and each country reacts differently according to its culture, according to its habits. And well, in Europe, as you know, there is quite a strong homogeneity about that. So we are not Asia. So some certain way to constrain people, to control people in Asia are not applicable in Europe, and particularly in France, because we are just different.
Yes, a very important control for peoples in European continent and Russian Federation. Thank you very much. Thank you very much for your position about this.
Could you please repeat my position about what?
About control for peoples in European countries and in Russian Federation. Very important. Спасибо. Спасибо. Thank you very much.
Thank you. About Europe, I answered to you, and about Russia, I think that Russian government has made the right decision. First of all, to to protect.
Yes, most interesting decision. Thank you. Thank you.
Thank you.
Good evening, Mr. Belot.
Good evening.
As you know, a new amendments in Russian Constitution of the Russian made in September. National law will be higher than international, and so our will be close up to USA law. Their states do not recognize international law. What do you think about it?
Well, I think that the subject is it's much more complicated that it may appear at first sight. I wrote in French a small article. It's on my website, but unfortunately it's in French about about Russian Constitution with some new amendments. I think that there are already many things some articles, some provisions in the Russian Constitution, giving the right to the judge, to the Russian judge, to control an international award according to public order, Russian public order. Russian perception of its own public order. So of international public order. So I think that everything is already inside and is already written inside the Constitution. And of course, I'm not Russian, and I don't know enough about your legal system. I have no education in your legal system. But my impression is that it's very much symbolic. It's very much symbolic to show that Russia wants to defend itself and will use legal means for that, and will put the stress on those issues of international awards and their recognitions and their importance in Russian legislation. And the reason for that is because there is a kind of trauma with the Yukos case. Because now Yukos former shareholders can enforce international award, and maybe they will try to do so in Russia. So it's to say that Russia will defend itself, and I think that it's very, very much symbolic. But as you know, people live with symbols, so it's important to do that for the Russian government. That was his position. So that's the only thing I can say. After that, Russia internal matters, and I absolutely don't want to make any comments about that. Russian government has its own agenda, and it's not a French attorney who will make any comments about that. Russian Constitution, unfortunately.
It was French Constitution. It's a presidential constitution.
Always had a very, very close relation. Normally, we should speak in French.
Thank you very much. Thank you.
Thank you.
Уважаемые коллеги, если те, кто еще хотел бы что-то спросить у нашего гостя сегодня, я думаю, что наша встреча завершается, потому что и так целый час мы находимся в прямом эфире. Позвольте поблагодарить вас еще раз, господин Бело, за то, что вы нашли возможность вместе с нами обсуждать важные вопросы, которые волнуют и коллег России и Франции. Я очень надеюсь на наше дальнейшее плодотворное сотрудничество. И еще раз хочу пожелать от нашего старейшего университета лично вам крепкого здоровья, французскому народу крепкого здоровья и скорейшего выхода всех из страшного этапа пандемии. Спасибо вам огромное.
Спасибо. Большое.
Спасибо.
До свидания.